Hello, guys. Welcome back to my channel again. It's your favorite lawyer. So, for our discussion today, we'll be looking at five key issues with respect to employment law or labor law in Nigeria. Because of the importance of this topic, I had to zero down 5 points that we can look at and one can consider because the issue of employment is paramount in one's daily affairs because you're either working as an employer or working as an employee, unless you're doing your own business alone and you don't have any employee. But the prospects are that you want to expand, you want to grow your business so that you can recruit more staff and have employees working under you. Now, termination of employment, it is not far-fetched that people come and go, like they say. They look in local parlance, we say soldier come, soldier go, but the barracks remain. So that means that you always have staff that will come and go. Today, an employee may be an employer tomorrow, so he will leave his employment and move to establish his own and become an employer. So National Industrial Court is the court that was established to deal solely with employment law matters, labor matters, and by the virtue of the Constitution, the National Industrial Court, it was established to take into cognizance modern labor practices by the International Labor Organization, and then they go beyond what is stated in the basic common law principles and try to employ recent fair labor practices. The judgments of the National Industrial Courts are usually tailored towards fair practices, and they tend to protect the employees because part of their mandate is setting up the industrial court was to ensure that there's to checkmate unfair labor practices. So initially, the courts would interpret an employment contract strictly, that if you're bound by what your employment contract says. So in that case, an employer is not mandated to give any reason why he wants to terminate the services of his employee. So the employers are not mandated because they are bound by their law as long as they follow what is in the terms of the contract. Because they usually in your employment contracts, you usually have procedures for termination because the employment is not it will not definitely last forever, and sometimes it can be the employer that wants to terminate the employee's services or the employee just wants to exit. So in this case, particularly with when it comes from the employer, what the courts currently hold is that you don't that you're not bound as an employer to state the reason why you want to terminate the services of your employee. So as long as you keep to the conditions in the employment contract, you don't have to state a reason. So you can just, because you don't want the person's services anymore, you can just tell the person to exit, tell the person to leave, as long as you follow whatever protocols in the employment contract between the employer and the employee. However, in as much as you're not mandated to state the reasons for which you want to terminate your employee's contract, the court in a case against Mikano International Limited, the company that's into the production of generators and manufacturing of generators and the rest, the court held in a case brought by one of its employees against the company that that terminating the employee's contract within 6 months of her resuming due to no fault of her. So it was not based on some negligence or the dereliction of duty or something that you could pin to her error. So terminating her contract within 6 months was too short a time, and the court held that is capable of destabilizing her. Somebody just got a job and you're just starting out. You haven't even and your career, you're trying to build your career, and just barely within 6 months, the your employer is terminating your contract. In that particular instance, the court held the dismissal to be unfair, and the court awarded damages against Mikano to the former employee who was wrongfully dismissed for no reason and within such a short time. So this goes to show that in as much as you are not bound as an employer to disclose reasons for which you want to terminate the services of an employee as long as you follow the protocol within the employment contract. The circumstances just have to be fair that are reasonable. So that is it with respect to termination of contracts. The second key issue with respect to employment law that we'll be considering is about the protection against discrimination. In employment relationships, the courts are very concerned about protecting the rights of employees particularly from against discrimination. So, like I stated earlier, the National Industrial Court was mandated to protect the rights of employees against unfair labor practices. So, in this regard, there's a case by one Mrs. Linda Jokanola against the Nigeria LNG. And in this case, the court upheld that the act of the company of LNG demanding that the woman should do DNA tests for her children when she applies for maternity leave. The court held that that was an infringement against the woman's personal life and it was discriminatory to her, because why would they want to pry into the maternity status of her children if the woman has held herself out to have children? It's none of the company's business to want to pry into the woman's life to really determine whether she's the mother of those children. That's a purely private affair between the family, between the parents of the children, if there are disputes. And it has nothing to do with labor practices. It has nothing to do with her work life. So why she requested for maternity leave and then she was asked to go and do a DNA test, the court held it to be an infringement against the woman's private life, against her person, and it was discriminatory to her. So you can see that in this instance, the issue of discrimination in the workplace should be properly considered, and in carrying out your acts as an employer, you have to ensure that you are not breaching your employees their right to their private lives, and you are not being discriminatory on in any front, in any means. So, like in this case now by Mrs. Linda, the court awarded her the sum of 10 million naira as damages, and the company was mandated to pay her that money for infringing on her private life. So, this now takes us to our third key point with respect to employment stroke labor related matters. And the third key point has to do with alterations in employment contracts, particularly unilateral alterations in employment contracts. Now, with respect to unilateral alterations in employment contracts, the courts know that in general human transactions, there will be situations that will lead to alterations in the employment contract. However, the courts have held that in as much as the company's operations and the nature of events that have occurred in the business environment of that company may lead to a situation where the employer will want to alter the conditions in the employment contract. In as much as the courts have found that, okay, yes, you can unilaterally change some terms in the contracts of your employee. But however, the courts have specifically demarcated it and distinguished that those changes you want to make in your employees' contracts should not have to do with their benefits, should not have to do with their entitlements and their emoluments. So probably you can change the conditions of service, you can change the situation around things, or work ethics. You can change those type of things unilaterally. And in this case, you can see that the court also tried to protect the employee, because it doesn't mean that, oh, because business is bad or something, you just want to just change the contract of the person unilaterally. The court will expect that you can call the parties together and talk to them and all that. If the person decides to continue, fine. If the person doesn't want, the person can now leave. But you can't just unilaterally change the terms of contract, particularly with respect to the person's entitlements and emoluments. And this decision of the court was in one case by one Mr. Haruna against Sterling Bank. That was where the court upheld this argument. Similarly, in another case, the court upheld an employee's 13th month salary, that the employer was bound to pay the employee's 13th month salary as long as the 13th month salary was a condition in the employee's contract contract of employment. So you can't say that, oh, because the 13th month salary is like a bonus, so you waive it just at your discretion. But as long as it is contained in the contract, the employer is bound to pay that amount. So you see that the courts aim to protect the employees' benefits, emoluments, and entitlements. And the fourth issue is with respect to bonds. So bonds, bonds, bonds in a contract, in an employment contract, there are agreements by which one is bound to stay a minimum number of years and not leave the employment within that minimum number of years. So depending on the condition, depending on the nature of the industry of the employer and the employee, some contracts come with those terms. For instance, the contract can say that the employee will not leave until he stays complete 2 years in that employment. This condition is usually when they feel that that industry or that particular sector is volatile and employees keep moving in and out, and so they want to keep them bound to those specific number of years. Now, while it is important to know that bonds are legal, but the court looks at the case in their entirety, and in some instances, the courts will hold that the bonds were unfair to the employees, and in some other cases, the courts have also upheld the bonds and held the employees who defaulted to ransom. So, for instance, in one case by Landmark University and Peace Ayegba, the court held that the terms of the bond were unfair and amounted to forced labor. So you can imagine the court equating the terms of the bond as forced labor. I mean, like slavery. So the court rejected the bond and didn't hold the employee bound by the bond that the employee had signed. However, in another case, also by a university staff against the university, Dr. Abubakar Shaban and Ahmadu Bello University, where the university had given the employee a study fellowship grant, and of course he had a term of years. He had signed a bond agreement with the university, but breached it. The court mandated Dr. Shaban to refund the university the salaries, all his entitlements, everything that he was entitled to for 6 years. In that case, the court doubled time of the bond. So the court in that instance upheld the terms of the bond agreement and found that it was unfair for Dr. Shaban to breach it when the school had sponsored him, giving him a study grant, and he didn't want to continue in the school's employment. He wanted to move on from there. So you see that in some instances, the bond will be held to be forced labor and unfair, and the employee will walk away. While in some other cases, the employee is bound by those bond agreements. So with respect to the issue of bond and bond agreements, the circumstances of the case will matter and will determine the way in which the courts will go. So in all of this, you can see that one has to ensure that as an employer, particularly, you are being fair in your decisions with respect to your employees, because that will now determine whether you'll be held liable or not with respect to your employment relations with your employee. The fifth key issue is that the courts uphold the sanctity of employment contracts. So by this, gathering from all my earlier submissions in this video, you will see that the courts tend to uphold employment contracts. The basis of this is a general contract law principle that parties are bound by agreements that they sign. And the Latin maxim is pacta sunt servanda. So you are bound by your agreement. If you sign any agreement, if you sign a contract, the courts will hold you to the terms of your contract. So generally speaking, the courts will not ordinarily depart from agreed terms in contracts. So the terms of contracts are fully upheld by the court, except, and this is because with every general law, With every general principle, there are exceptions. So the exceptions to this is where those conditions are unfair, where the conditions are unreasonable and will lead to unfair labor practices, discrimination, forced labor, and the likes. It is in those cases that the courts will jettison or ignore those particular provisions of the contract and apply principles that are fair and equitable to the interpretation of those contracts. So be careful what you sign for. Be careful what you agree to do in your employment contract. Whether you are an employer or or you are the employee, you have to think through before you put your signature down in that contract and accept the contract to resume work in any organization. This therefore brings us to the end of this video, and I hope you got value. Kindly do well to go through all the key issues so that you don't run breach or you don't run foul of the law with respect to employment or labor related matters in Nigeria. Kindly do well to like the video. Also, please subscribe to the channel so that you get updates when further videos are uploaded on the channel. Thank you. I'll see you in my next video. Bye.